Hello everyone, we are back live again. Today is July 28, 2026. This is our fourth live with Leyla.
Yes,
Leyla, welcome.
Thank you.
So as we always done, we want to talk about first regarding the last week's immigration developments, and then we will start answering your questions. I want to talk about the H-1B 100K rule. What is the most recent update, Leyla?
So the most recent update is that the circuit court, which the government appealed to, because a lower court in Massachusetts had a ruling that said that the $100,000 should not be collected. And then the government appealed. And once the government appealed, the same lower court stayed its own rule, meaning that they said, okay, the government can continue collecting the $100,000 until the outcome of the appeal. Now, the circuit court has done a preliminary review and believes that the government will not be successful in the appeal, and therefore has instructed the lower court to take the stay off. And that ruling is in place and essentially means that now USCIS cannot collect $100,000 for H-1B.
Okay, that is great to hear.
Yes.
For H-1B applicants. So there are, I guess, three levels of federal courts. The first level is federal district courts.
Correct. Yes.
And then the second level is circuit courts.
Yes.
And the third level and the ultimate level is the Supreme Court of the United States.
Correct.
So which federal district court has stopped the 100K initially? Was it Massachusetts?
Massachusetts, yes.
And then Massachusetts is under the First Federal Circuit Court.
Correct.
And now the First Circuit Court looks like agreeing with the lower court.
Correct, yes.
Okay, that is great news.
Yes, that is
so
great.
Hopefully when they decide on the merits, the fee may be vacated fully.
But as it is right now, if someone has to pick up an H-1B outside of the U.S. and apply for consular processing, they can do so without paying the $100,000.
That is great. How about the applicants who already paid the fee?
I don't know. I guess maybe the decision will have some relief for those people. We have to see. Yeah.
Yes, that will be interesting.
Yes.
I guess the government doesn't like refunding the monies, but
Yeah.
if there is a court order,
Correct.
that is a possibility.
Yeah.
Okay. Another topic I want to talk about is that the affirmative asylum application announcement that was done yesterday by USCIS. What do you know about that?
You would have to elaborate on this, but based on my understanding, if there's late filing, some sort of criminal or security concern, or if a person does not file and is able to show a ground for asylum, those cases will be referred to immigration court without an interview at USCIS. Am I right on that?
Yes. So that is kind of concerning because many asylum seekers have their applications pending for many years before USCIS because of the backlog. But now they are at risk of their cases will be transferred to the immigration court, where the judges are under tremendous pressure because they are operating under the Attorney General, meaning they are not Article 3 independent judges. They are kind of administrative judges under Department of State, Department of Justice, and the judges who have higher approval rates, maybe more than 100 of them, were fired by the Trump administration. And as far as I know, and there was a New York Times reporting on that, the asylum approval rate at the court level is around now 6%. So it will be much tough for asylum applicants if their case is referred to the immigration court. And I was watching an immigration attorney's video on this issue, and she was saying that USCIS will have electronic scanning. Looks like not like every application will be reviewed by a person, by an officer. Instead, maybe an AI or a software will review the applications, and if they see that the application is filed more than 1 year after entering the US, then they can automatically be referred to the immigration court. But what if the applicant has an exception to the 1 year rule? It is not clear. So they are also removing the language from the regulation saying that interview is not a right anymore. So whenever they want to refer your case to the immigration court, and it will be on their discretion. So if an officer thinks that the asylum application doesn't have much merits, then they can also decide to refer before conducting an interview. That is very troublesome, and I hope that it will be limited to it will be limited to certain applicants who have criminal backgrounds, etc. But we are seeing a trend that the even before they publish this rule, we see many applicants refer to the immigration court. So they just kind of formalized it now.
So is this somehow the officers clearing their backlog? They can also use that to clear their backlog, right? So if they have a lot of asylum cases and they just decide to refer them all to immigration court.
As if there is no backlog at the immigration court. So it is kind of counterintuitive to me. But I believe that there is around 1.4 million applications pending before USCIS, and maybe around 2 million applications pending at the court level. But why do you refer those cases to the court where the court has itself have much more backlog?
And it will be very costly also for the applicants, because now the attorneys would have to attend hearings and...
Definitely. And generally, if a case is referred to the immigration court, their requirements are different. And current regulations allow immigration judges to pretermit asylum applications based on very minor deficiencies. So what if a case is referred to the immigration court and then the judge pretermits the application? Then the applicant has no choice but just to appeal the decision to Board of Immigration Appeals in a very short time. And it will cost them money because they have to hire attorneys for that appeal as well. Yes, and other than these, I want to talk about B1, B2 pilot program where an applicant can pay additional money to get an earlier interview. What do we know about that process?
So we know that the Department of State is running a pilot program. Right now, it's only at the U.S. embassies and consulates in Mexico, where for an additional $750, you would be able to get an appointment within 10 business days, subject to availability. I believe B1, B2 appointments all over the world are very backlogged. And I believe the government is trying to take this additional fee to expedite those appointments. And it's going to be a good source of income as well for the government. If it works well in Mexico, they will probably start rolling it out at other consulates as well. So we would have to see how the outcomes.
Currently, only B1, B2 applicants at the consulates in the Mexico.
Mexico, correct, yes.
And if it works well, then they will expand the program to other countries.
Yes.
And for $750, maybe it makes sense to get an earlier appointment.
Yeah, because in some consulates, I haven't checked in a while, but in some consulates, the wait time for a B1, B2 is like 365 days, over a year or even longer. So if you pay an additional $750 and are able to schedule one within 10 business days, it says subject to availability. So we would have to see how this all pans out. But they might basically have it at other consulates as well.
Definitely. I also remember that in Istanbul there was a backlog of a year and a half. So it makes sense if an applicant has, let's say, if there is a family member, important days such as like weddings and etc.
Correct.
So
Yes.
people are willing to pay that
Yes.
money. And there is another trend that worries a lot of immigrants. Can you briefly talk about the arrests at the airport and who should not be traveling domestically? What do you think about that?
So based on what I've heard on the American Immigration Lawyers Association, there has been a lot of reports that even people that are traveling domestically are being detained. Mainly the cases that have been reported are cases that already have an asylum or an adjustment of status application pending, but their underlying status has already expired. And some of these people that are being detained do have valid employment authorization cards and advanced paroles. So that is very concerning to hear, that even though they're here and they filed in time, and they do have employment authorization and advanced parole, they're being detained for traveling. So in the past, we would always tell clients to not travel internationally, but now
even domestic travel is risky. Yes, and as much as I know, the employment authorization card itself is a real ID.
Correct.
But even with this real ID, this does not protect you from detention. As long as you don't have a valid status, even though you have a pending affirmative asylum application, for example, they can detain you.
Yes.
And also, if you are a spouse of a U.S. citizen,
correct,
but you filed your application after your, let's say, B2 or F1 status expired, then you can still be detained.
Correct. And in the past, I had always advised, I don't know what's going on.
Do you want some water?
I'm fine. I don't know if that's going to help. But in the past, I would always advise my clients that did not have an employment authorization card not to enter an airport, because an airport is a federal building. But now, even the ones that do have employment authorization should take caution.
Definitely. Yes, this is very concerning. And we also hear some news that they started to detain people at the interviews as well. Like the applicant is a spouse of a U.S. citizen, they go to a marriage-based green card interview, but they are still being detained at that interview. It is yes. concerning. So hopefully that trend will not be continuing. So let's get started with questions. We have collected 3 questions prior to the live, and then we will switch to the questions that was asked during this live. So the first question, do you want to take this one?
Yes. My employer filed my H-1B online, and I upgraded to premium processing last week, but no receipt yet. Does USCIS upload receipts, RFEs, and selection notices online? If mail never arrives, what should we do? So yes, generally USCIS, once you do have an online USCIS account, will upload the receipt notices, RFEs, any kind of notice that you will be expecting should be uploaded to the online portal. It's only been a week since you filed premium processing. I would check the status also online using the H-1B receipt notice and see if it has any indication that it was already converted to premium processing. And I would generally check the status on the portal and make sure that nothing has been updated. If he doesn't hear back, I would call the 1-800 number and see if they can give you some insight.
Also, it is not clear from the question whether the premium processing form was filed online. So it can be filed online and you can see the receipt notice very quickly.
Yes.
But if you mailed it, maybe there yes. might be a little delay.
Yes, it takes time. Sometimes I had seen in the past that sometimes we even receive the approval notice before we receive the receipt notice,
wow.
even with premium processing,
wow.
if it's not filed online.
Mm-hmm. Okay. There is another question regarding VAWA. Do you want to take this one?
Married to a U.S. citizen, lived in Philippines. I was abused. Can I file a case in the US. My husband is not in the military. Sorry, my understanding.
Okay, so as much as I understand, this person is asking about their eligibility regarding a VAWA application, which is Violence Against Women Act,
Yes.
which allows spouses of U.S. citizens or green card holders, if they entered into marriage, if they entered into a genuine marriage, and if they are abused during that marriage, they can file for a green card, basically. So if the abuse was done in outside of the US, are they still eligible for VAWA?
Yes, they are.
Yes, they are eligible for VAWA. And even if you are currently in the US or you are outside, you can still file I-360 VAWA application.
Correct. And it doesn't, the spouse does not have to be in the military or the government. That's not a requirement.
Yes.
As long as you have evidence of the abuse, you can file a VAWA application.
Okay, thank you. And let me read the question. I am on STEM OPT expiring January 14, 2027. My H-1B change of status application is pending. Can I do a service transfer to a day one CPT university without affecting my H-1B application? Because of new DS rule, I want to join university before September 15. Do you think it is necessary, and what should this person do?
I don't know all the facts, but based on what I'm reading, I don't believe it is necessary because under the cap gap, this person will be covered until April 1st of 2027. And so hopefully the H-1B will be approved before that time. And if the H-1B change of status is not approved and they're reaching that date, I would suggest to convert to premium processing as opposed to applying for day one CPT, unless they don't believe on the merits of the H-1B application. And for precaution, they want to apply for day one CPT. As long as the H-1B hasn't been approved, there's no, applying for day one CPT will not impact the pending H-1B.
And we have a lot of time until April 1st, 2027. Yes. And I think even without premium processing, it is very likely that the H-1B will be adjudicated by then.
Yes.
So there is technically no necessity to do
unless they don't believe in the merits of the H-1B.
Yes, okay. All right, so let me switch to the questions that was asked now. Emma Thomas filed I-130 while I was green card holder, requested citizen upgrade, got email, finally upgraded it after 10 months. Does this mean they are reviewing our case? Could approval be soon? Spouse live in another country. So let me tell you this. I have a lot of clients in similar situations. So I did file a Mandamus case because USCIS did not timely converted the application to IR1, which is immediate relative category, and there was a delay. So as soon as I filed the application, we see meaningful developments in the case. Either there is an RFE or we just received the approval notice. Regardless, I mean, 10 months is a very long time. I think it is unreasonable. And if your I-130 application has been pending for some time and it looks like it is pending, you should definitely consider filing a Mandamus lawsuit. In my opinion, it is very likely that you can get successful outcome. Do you want to say anything else?
Yes, I believe even if the case was upgraded to spouse of a U.S. citizen, there still might be a big backlog. And I do believe a Mandamus case in this situation would help move that forward.
Yes, even without upgrading, these cases now take around 13 to 15 months, but looks like you have your application pending even before upgrading for some time, and 10 months after that, I think you should not wait anymore. Another question, My attorney is too slow. I applied asylum after 1 year deadline. We will send I-130, I-485. I would like to find another attorney, but I am worrying if I can't take the money back that I paid full amount. Is there a question here? I don't see it. Do you see
No, I don't
any
see
follow-up
a
message?
question.
Okay, so based on this, I would be a little bit concerned because now if they refer your asylum application to the immigration court because of the rule that is announced yesterday,
Yes.
then you can no longer do I-130 and I-485 together because you are technically under removal proceedings now.
Correct. Yes.
So first, that proceedings has to be terminated, and currently judges are not willing to terminate any removal proceedings. So I would not be worrying much about my fees if I am at this risk.
Yes.
So either you push your attorney a little bit because of the yesterday's announcement, or just lose the money and
File right away.
Yes.
As soon as possible.
As soon as possible. Murat Verdiev is here again. I entered the US on August 20 last year, and I am currently on OPT status. I wanted to clarify whether filing my asylum application about even 2 weeks before the 1 year deadline is acceptable without any risk, and whether this 1 year filing deadline applies to someone who is maintaining valid status like OPT. Since this is an asylum question, I can take it. So as long as you file it in 1 year, the risk is much less, and they don't care whether it is like 1 week before 1 year deadline or 2 weeks. So file before 1 year. Technically, it is an exception to have a valid status like F1. So even if you pass 1 year deadline, you can still do that. But as we talked before, maybe a software or AI will review these applications pending before USCIS and refer them to immigration court without looking at the details whether any exception applies. So I wouldn't take that risk. I would definitely file the application before 1 year deadline.
So if someone is in valid status, does that 1 year apply from the date their status expires or from the date that they enter the US?
So 1 year deadline is about physically entering the US. But if the applicant has a valid status, let's say for many years, like F1, and then while they are in the status, if they apply for asylum, it can constitute an exception. But I wouldn't recommend filing an application after their status expires. That can be very problematic. They can still argue something, saying that, oh, I waited because I wanted to change I wanted circumstances to change in my home country, and I don't want to backlog the US asylum system. But in that scenario, it can be much more challenging to argue the changed circumstances and whether the time passed after your status expired is reasonable or not. So I wouldn't take that risk, especially now. All right, so Ahmet Alkış says, my case is genuine, but I get extremely stressed and nervous during interviews. What can I do to avoid giving the officer the impression that I am not being truthful? It's a general question, I guess.
I think this happens to a lot of people. Even it happens to the US citizen spouse in a lot of interviews, just because the atmosphere over there is very intimidating. I believe officers also understand that, and they can see if you're stressed because of the whole environment. What I would do is, if I hear a question that will need time to think about it, I would think about it. I would let the officer know if I can't recall. As we discussed before, I would just not guess or make something up. So I think officers understand that situation.
And you can tell them
Yeah.
that, like,
Yeah.
oh, officer, I am so excited or nervous. I apologize in advance if I cannot answer your question clearly. Or if you don't understand the question, just tell them.
Yes.
Can you repeat it? Can you clarify the question without guessing it first? So
Yes.
other than that, most of the time, officers interview hundreds of applicants. They see many people, so you are not the only one who are
Yes.
very excited about it. Okay, I applied for asylum based on a gay case. If my asylum is denied, or even if it is not denied, but later I change my sexual orientation, become straight and marry a woman, would I be able to get a green card through marriage? All right, so let me be clear. So they don't just look at your most recent application. They will review your whole immigration history, and especially under this administration, if they think that there are some red flags in your application, they can question you in very detailed manner. So you should be very careful about this. And as long as your history is genuine and bona fide, I wouldn't worry, but I would do my homework very well.
Yes, and I believe that these days they also look at social media. So they will look at social media to see if they find any red flags on the social media. But as long as it's truthful, there should not be an issue.
Yes. But be prepared. Maybe there can be site visits as well.
Yes.
So they can question the bona fides of the marriage by asking your landlord, your neighbors, your employers, your colleagues. So you should have everything. You should be prepared for everything,
Correct.
in my opinion.
Yes.
Okay. Mackenzie asks, when I-485 interview I-130 approved 2 years ago, F2A, should we expect that officer will focus I-485 applicants solely? What should be best example of intent change before 90 days to submit this I-485? I think I recall this person from last live because there was an issue regarding filing the I-485 before 90 days period after the last entry. Do you remember that?
I remember that, but I'm trying to understand the question. So this I-130 was approved 2 years ago because it was F2A, permanent resident?
Looks like, yes.
And then I guess the beneficiary came to the US and filed a 485? Is that what you're understanding from the question?
So I initially thought that they came to the US without previously filing I-130. They filed both I-130 and I-485 at the same time before 90-day period. And then they got the interview and the I-130 was approved, but the I-485 was not adjudicated because there was no availability, visa availability due to F2A category. Now they are concerned about I-485. I initially understood that way, but it can be that if I-130 was approved before even they enter the US, then there should be much bigger concerns because you already showed your immigrant intent and you filed the I-485 right after the entry, then there should be much more red flags regarding the intent issue.
Correct. I would only document any evidence that I had to show that when the person came to the US, the intention was temporary, and because of change in circumstances, they decided to stay and file a 485. That's the only thing that I can suggest.
Definitely. For example, if they did not resign from their job, from their home country, it can be one evidence. Okay. So this question was answered. Let me see, there are duplicate questions here. Johnny Brown. Hello, my wife is a green card holder. I am on F1 status. Next month, F2A will be current. I have worked with my SSN about 7 months before filing, but my lawyer selected that I didn't work. Can I get green card? Okay, so I think you should be worried about that, or you should do the correction before the interview, saying that you got misleading advice, and first of all, like you should not provide any wrong answers
Correct.
to federal government. It can bar you from immigration benefits forever. It can be very problematic. And your wife is a green card holder, so if you worked without authorization, you cannot get I-485 approved if you have unlawful work history.
Yes.
Am I right?
Correct. If he was married to a U.S. citizen, he would have been forgiven.
Yes. So if you are on F1 status, I wouldn't file the I-485 unless until my spouse is a U.S. citizen.
Correct.
Right?
Yes.
And you should have been aware of it. And now I think the situation is not looking very good
Yes.
for you.
I'm not sure how he obtained the social security number. So unless it was obtained because of hardship, economic hardship, which you would then be able to work, then so.
So sometimes, like, universities and colleges provide part-time on campus work authorization. It can be that as well, or CPT. Do you think they got their SSN through that way? But after you got that SSN, you work without authorization for someone else as well, then it can be problematic. So you can either make that explanation, correcting it, and you will probably get denied, because if you marry a green card holder,
Yes.
that is not forgiven.
Yeah, so I would actually wait, because it seems like he hasn't filed the 485 yet.
So
Next month,
the question
F2A will be current.
but it asks, my lawyer selected that I didn't work. So it looks like they have already filed the I-485. So you should definitely talk to an attorney regarding this process.
Correct.
In a private consultation meeting. Okay, another question. My priority date became current in August, bulletin under F2A. I am 20. Can I be sure that possible bulletin retrogress won't make me age out? My I-130 is still pending. Can I assume my age? So looks like this person is F2A because they are a child of a green card holder. And if I am not mistaken, Child Status Protection Act covers these type of applicants as long as the I-130 was filed before they reached the 21 age.
Yes.
Do you have? And looks like you will file the I-485 next month.
So once the 485 is filed, based on my understanding, the age should stop once the 485 has been filed. So as long as the person is under 21 when they're filing the 485, that the age should stop at that time.
Okay, so the age will be deemed as frozen.
Yes.
At that time.
Yes.
So just file the I-485
yes.
As soon as possible. Maybe they have filed already, I don't know.
It says August. It says it's going to be current in August, right?
Yes, but the dates for filing became current for some time now. Yes. So they might have filed the I-485 already. So I think you should be fine. Another question, is there a chance that this new asylum policy could be blocked by a judge? I think it can be blocked because this is so substantial change,
Yes.
and they did not go through comment period. They just published it as interim final rule, so it is effective immediately, kind of thing. And I think it will be challenged, and I hope like the non-governmental organizations like ACLU and other organizations will challenge this as soon as possible, because this is so problematic. And we will be updating you if there is a lawsuit filed about this. Okay, another question. How do you go about accessing your file first? And are there people in your company who speak French? Do we have anyone speaking French? I'm not sure. So I don't know. Maybe we should ask the team. We are growing fast, but I'm not sure about French abilities. How do you go about accessing your file first? So if a prospective client has an immigration history, I recommend them filing a FOIA application before taking any action. Then FOIA Freedom of Information Act allows you to get the copy of your alien file from USCIS, and it is generally fast. In 30 to 40 days you can get your get the scanned copy of your application from USCIS, and as attorneys we can carefully review those files, and then we can advise whether you are eligible for certain benefits.
That's the best option.
Yes. Another question, so there is no question here. I entered USA through Mexico, and I have been here for 4 years, and I am from Burkina Faso. This is about same question with this one. So if you are in removal proceedings, you can your attorney can download the document called EROP, Electronic Record of Proceedings, from Immigration Court System. You can access your file from there. But if your removal proceedings has not been started, then you can request FOIA from USCIS or CBP, and you can get your alien file. All right. Another question. I am an MD that completed his residency and got licensed in the US on work permit through pending affirmative asylum case. I came in on J1 visa originally. My asylum case is still pending. Is H1B possible?
So H1B is, I believe this person is subject to the 2-year residency requirement, because medical doctor on J1 most likely is subject to the 2-year residency requirement. The only way that he would be eligible to apply for H1B is if he applies to the Conrad waiver program, and he's accepted into one of those programs. And then he basically they will apply for his H1. It's for underserved areas where they need doctors, and basically the hospital will generally apply for the Conrad waiver. And once that is approved, they can apply for H1B. And once they serve in that program for 3 years, they become eligible for an adjustment if they have an underlying basis for it.
Okay, so is Conrad waiver required for both adjustment of status and change of status?
Yes, for H1B. Yes.
Okay, for H1B it is required. Yes. But my concern is, I have another concern here. To my understanding, even if there is no 2-year home residency rule, I think this person has lost their status, and then they only have pending affirmative asylum. So pending affirmative asylum does not constitute that status, so you cannot change your status because you currently don't have a status here.
Yes, because he said he started working
in
on the EAD from the affirmative asylum.
Yes. So Unfortunately, you cannot do change of status in the US. The only way you can do, if you are not subject to 2-year residency, you can do consular processing for H-1B, which can be a little problematic because you also say that you cannot go to your home country, right?
Yes.
So maybe a private confidential consultation with an attorney can be a better option for you. All right, another question. Thank you for hosting this Q&A. My question is there a chance that immigration court might be backlogged after the news that USCIS will start referring cases to immigration judges? I think we already talked about that in the beginning. I believe there are around 2 million, maybe more than 2 million asylum applications pending already before the immigration court. They are backlogged already, and the situation will become much problematic. But at the same time, they are pretermitting, meaning that they are closing asylum applications even before hearing the case fully, and they just find excuses to close applications. For example, there is a question on the form I-589 asking about travel before entering the US. In the past, we would put, I will answer this question in my statement in a detailed way. But now, if you don't put like very detailed explanation about the travel history, they just pretermit your application and they don't even hear you. So the idea that the government has now, they will just try to pretermit cases as soon as possible. So they essentially do not want to hear your case either before USCIS or the court. So you should be very careful. You should be on top of your case. You should be talking to your attorney. And this situation is getting very troublesome, and they give you earlier court dates, even without your knowledge or your attorney's knowledge. So you should definitely check immigration court website very frequently, so that if there is an update, you should take action.
I believe the immigration judges are also under a lot of pressure, right? Because they also have to meet a certain quota as to cases that they have reviewed in a year. Is that correct?
Yes. So they are in a rush. There is a pressure to expedite the processes, so they don't accept like motion to continue anymore, like unless there are some very serious reasons. So they don't accept those. So they want to get rid of cases as soon as possible as well. So this is the question that we answered initially. Do you want to take this one too?
Okay, so hi, thanks for addressing my question regarding CVIS transfer to day one CPT. While H-1B is pending, actually my HR filed application with my support and no attorney involved. So I'm not 100% sure. I upgraded to premium 10 days ago via online account, but haven't received any receipt notice by mail or online. Forgot to add fax number in premium application, so as a backup want to do CVIS transfer. Current case status is application changed to premium processing case. So it does seem like they did convert to premium processing. So you should have a decision within some sort of correspondence within 15 business days from the date that it was converted to premium processing. You might want to do research on day one CPT, since he's saying that he doesn't have an attorney involved. I don't know the merits of the case. So he might want to do the research on day one CPT, and if there is an issue with his H-1B application, have that as a backup plan.
Definitely.
Yeah.
But looks like they converted the case to the premium processing.
Correct.
I would still wait,
yes.
because you will very likely hear from
Yes.
USCIS very soon.
And if you do receive an RFE, a request for additional evidence, and believe that you would need an attorney to assist you and maybe have that approved, that's something that you should also explore.
Definitely. you can always reach out to us.
Yes.
If someone is detained and their case is closed due to absentia order, but appealing at the moment to reopen the case, can they get bond or habeas? So I think yes, based on due process, we do file habeas cases all the time, and they require review of the immigration history. Like at first sight, I can say that yes, you can get bond or habeas. It is possible, but we need to look at the details as well. Do you have anything to say?
Okay. Not on that subject.
Okay. Would you recommend Mandamus for citizens of Turkmenistan with pending asylum at this period of time? Thank you. So there is no ban on Turkmen citizens if they have a pending application in the US. So if the applicant is in Turkmenistan, and if it is a green card case, then they are subject to 75 country public charge rule ban. But if they are in the US, I would recommend Mandamus, and we filed Mandamus actions for many immigrants who are from these countries, and they were successful in expediting the application. And as you know, a federal court judge vacated all those policies, so there is no ban currently, and we are receiving approval notices for Turkmen nationals and other nationals as well. So definitely, if there is unreasonable time has passed, we can help you with that. You can reach out to us. There is a phone number here or email address. You can reach out to our firm so that we can do free Mandamus eligibility for you. All right. We have a lot of questions today. So I used 2 re-entry permits to finish university abroad, then returned to live in the US. After Mandamus, USCIS scheduled a petitioner on the I-130 interview. Could my re-entry permit history be the reason? I remember this person as well, but during the previous slide, they did not mention that they used re-entry permit. Yes, I think you answered to this person without knowing that they use re-entry permit. So the USCIS might think that you lost your status, green card status, because of the prolonged departure from the US, but you can argue that you never abandoned green card just because like there was some extraordinary circumstances you filed
for the re-entry permit.
For the re-entry permit. And I think that can be it. Right? That can be your history, because this is unusual. We mentioned that during the last line.
Yes, and it might be they want to make sure that the intent is now to remain in the US, so the domicile intent part of it as well.
Can they do anything proactively before the interview?
Well, I mean, as far as domicile is concerned, if they have any lease agreement or if they have a job offer that shows, yes, I've leased this house for like 2 years, that means my intention is to stay here for 2 years at least. Or if I already accepted a job offer, that
do you mean for the future? For
the future, yes.
Okay.
Yeah.
Do you have any recommendation for the history? Like, do they need to show anything, even with the re-entry permit? Do they have to provide lease agreements showing the history of, like, do they have to do that?
I would not look for lease history for somebody who applies for a re-entry permit. They know that they're going to stay outside, but make sure that the ties are still to the US. Like if they still have a bank account in the US, they can take that. And if definitely they had to pay taxes. So if they have filed tax returns, those documents show that you never broke ties with the US.
I think this is a very important recommendation. Maybe you should download your tax transcripts for the years that you were abroad, and then it can be a good evidence during that interview. Okay, hi, I filed for affirmative asylum about 6 years ago and I'm still waiting for my interview. After a short marriage, I experienced financial and emotional abuse and I may qualify for a VAWA. What would I do? So, first of all, I have filed hundreds of mandamus cases for affirmative asylum applications, and if you think that your asylum application is strong, you can definitely expedite that process by filing a mandamus action. In the alternative, if you think that your VAWA is stronger and you don't want to pursue your mandamus, you can also do VAWA application, Violence Against Women Act. But definitely you need, so you mentioned that it is a short marriage, then you should have strong evidence to show that the marriage was entered into good faith.
Correct.
And not just for immigration benefits.
Yes.
Do you have anything else?
And of course, evidence of the abuse.
Evidence of the abuse, yeah. So if it is just like emotional abuse can be considered, but under this administration, they recently discovered that an attorney has filed 54,000 fake VAWA applications, and because of that reason, they are reviewing every application. They scrutinizing those applications very carefully, so you should have a very good evidence package attached.
Correct, yes.
All right, so there is a person, right? I don't see any question here, so I'm just skipping it. Is it okay to travel to the US on existing B1, B2 visa with your spouse if you have a pending I-130 application? How risky is this? The intention is a trip to the US, not to adjust status. So I had this situation many times for my clients, and thankfully, after they were able to show that they had many travels in the past, and they always went back to their home country after a short stay. And since I-130 takes a long time and they don't have short-term plans to stay here, I think CBP officers is understanding
Correct.
this,
Yes.
and I wouldn't worry much about that. And if you want to keep evidence of your current work at your home country and your ongoing lease agreements, etc., that can be helpful, even if you are pulled to the secondary inspection. Am I right?
I agree, and yes, you are right. Travel history, especially if the B1, B2 was valid before this person filed the I-130, I would, if the officer questions, I would say, I had a B1, B2 visa before I even got married or before I even filed my I-130, but my intention isn't to immigrate at this minute right now. And that's why I didn't come into the US and file for an adjustment, even though I had the ability to do so with my B1, B2. I filed outside. I selected consular processing because that is my intention. My intention is to apply through consular processing. And if, as you said, they do have a good travel history showing that they went back and forth and they didn't stay in the US and apply for an adjustment, I believe that they should be fine. And as you suggested, documentation to show ties back home.
Definitely. And if you have travel plans, definitely have those ready. For example, if you have a return flight booked, have that evidence ready. And if you have any plans in the US, like hotel reservations and travels, so be prepared to provide those as well. All right, we should be wrapping up soon, but
is there one in a private chat extra?
So that is Erdem.
Oh.
My boyfriend is an asylum seeker and his asylum interview is still pending. We are planning to get married. I have a green card and recently applied for US citizenship. What would be the best strategy? If you apply for US citizenship, for example, in New Jersey, it takes around 6 to 8 months now. I don't know where you are located right now, but if you get your US citizenship, you can file I-130 and I-485 at the same time for your future spouse. And generally, those applications are being adjudicated in a few months. They are going very quickly this is a good news. But at the same time, sometimes they are detaining applicants like your future husband during that interview, and quickly after that those applicants can get released on bond. This has happened like 5-6 months ago in San Diego, California, and I heard this week that they did it again for certain applicants. I don't want to like give you like I don't want to make you nervous, but there might be a little bit risk over there. But definitely, if you get your citizenship, you can file I-130 and I-485. And if I were you, I would do that. You can file I-130 now, and you can upgrade the petition once you get your citizenship. But it is not really necessary, in my opinion, at this step.
Because he's already here in asylum, so
Yes.
there is no
benefit. And upgrading sometimes takes a long time.
Yeah.
So just filing concurrent application after you get the citizenship makes much more sense.
So after this person files the I-130 and 485, then they have to withdraw the asylum application?
I generally don't withdraw the asylum application until the green card is received. And sometimes asylum office discovers this. After the green card is adjudicated, they send you a letter saying that, oh, we understand that you are already a green card holder now. If you don't respond to this letter, we will be closing your case. So if you still want to keep the case open, you can still do so, but there is no need for that.
But knowing that they might now be scheduled, referred to the IJ without an interview, how do you feel about that? Because it says he's still waiting for
asylum interview, and what you say is after yesterday's announcement, yes, there might be a risk. I just hope that this asylum applicant doesn't have 1-year rule problem or criminal history and etc. But even if they file the I-130 now, it doesn't protect them from referring to the immigration court. So I would still wait until the citizenship
is filed.
Yes. I think audience should ask their questions in one message, otherwise it is very confusing for us. So I am just skipping Peter's question because I don't have all the information. I'm sorry. Okay, Mariam is asking, my husband is a mechanical engineer, 9 years experience, we live in Germany, Turkish citizens, German citizenship next year. I work in pharma supply 2 years, want to move to USA, what visa do you suggest? So if you are an engineer, there are certain ways for you to immigrate to US. That can be an EB2, EB3 categories. These are highly used ways, but the EB2 and EB3 perm takes a few years, regardless of you have a German citizenship or not. So it doesn't have much importance here. Do you want to say anything else?
Basically, if the company he's working for in Germany, I'm not sure if they have another branch in the US, maybe there could be an L1A transfer between the companies.
Or even if they don't,
even if they don't have that, maybe an E2 investor category in the US. So this is something that requires, I believe, a consultation.
Okay.
Yes.
So I think you touched upon a very important thing that I initially only thought about, permanent options like yes, EB2, EB3, which takes a long time. But if you want to move quickly, then you can choose E2 investor visa or L1 intra company transfer visa, yes, which, like, if you work for a company and if they have a US branch, they can transfer you, or if they don't have a branch, they can transfer you still as an executive to create a new office. Yes. So you have E2 and L1, and in the alternative for green card options, EB2 and EB3 perm, but it will take likely 3 years or more.
Correct. Yes.
All right, so Peter, okay. Erdem Bey, can you bring Peter's question? Okay. I have I-130 and I-485 interview. I already rescheduled once, but it again came after a month. Can I reschedule again? My wife is a PR. I was out of status 13 months, and I have unauthorized work. Will they arrest me in the interview, or should I reschedule again and wait for my wife to be a citizen? So no one can guarantee you whether you will be arrested or not. I had a client. We initially rescheduled their interview for the first time, and for the second time on the interview day, the U.S. citizen spouse had a panic attack, so they could not attend the interview, and the non-citizen applicant went to the interview and provided the evidence and requested another rescheduling. Even though the officer was understanding that day, we received a denial notice on that day. So they might not accept second rescheduling. It will be riskier. If you want to, you can withdraw and refile once your spouse is a U.S. citizen. But I would still want to, if I were you, I would still want to continue the I-130 petition, because it might take a long time to get that, so you can attend the interview. Whether they will arrest you or not, you can take a look at the news. Generally, if they arrest people at that office, you can see that from the news. Generally, we don't see that happening. Yes. Like at field offices in the East Coast, but it happened like in San Diego, so everyone is aware about that. But they stopped doing it, so I don't think the arrest risk is too much, but no one can give you assurance. Okay, so it's been already more than an hour. Should we wrap up?
Yes.
Okay. So thank you everyone for attending our live. I hope this was helpful. We will be planning to keep these lives every Tuesday at 2 p.m. So if you want to get notified, you can definitely subscribe to our channel, and you can turn on the reminder for the next session. And you can also subscribe to our newsletters on our website. We can definitely inform you about the upcoming lives as well. Thank you for attending, and have a great rest of your week. Bye-bye.
Bye-bye.